Be cool, be kind, be classy. The cupcakes so sweet and sexy. Have fun, enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. Not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions of lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Sack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Meshegas. Ridiculous that insanus. Oy vey, Marcus. Proceed, that's for schmucks. Be cool, be kind, be classy. My cupcakes sweet and sassy. Not just a YouTube show. When you know, cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Good afternoon, my friends. Good afternoon. Today is Tuesday, August 12th, 2025, and we're going back to Dedham today. We're going back to Norfolk Superior Court for the continued hearing on the Myles King case. No testimony is expected, so I don't know why NBC 10 has their headline as Michael Proctor is expected to testify today, because he's not. I don't know if that's like clickbait for them. This is a non-evidentiary hearing, and so there will be no testimony today. What we're going to do is they're going to continue the hearing from, I guess it was only last week, right? And talk about whether they were able to get together and make the appropriate charts for Judge Krupp that he wanted to see about what discovery was turned over late, what wasn't turned over late, why it's prejudicial. And so we expect to hear some stuff about that. And then they're also going to have a hearing with all of the attorneys in all of the companion cases, I call them, that also involve Proctor, in which the text messages from the feds were set to be destroyed pursuant to federal order 30 days after the end of the Karen Reed case, which would have meant they would have to have been destroyed by July 18th. And it has been extended, and we are waiting for it. So we'll see Rosemary Scapicchio. There's also other stuff that dropped today. There's a bunch of documents that dropped today in the wrongful death case, in the civil case, and the Proctor Internal Affairs report is out. So there's a lot of stuff. It's unusual for us to start in the afternoon, but here we are. I'm here for it. We're here for it. So I think I really want to see that motion to dismiss on the Karen Reed civil case. So let's see how long this hearing is, and I'm sure we'll probably have enough time because we can't finish ever. There's always more stuff to talk about. Like it just literally dropped like 5 minutes ago. So we're here for it, and we're waiting for the feed to come up on NBC 10 Boston. So how's everyone today? How's everyone? Karen became a new member. Welcome, Karen. I think you're going to like it here. How's everybody doing? No power for 36 hours. Where are you, Cammie Birch? That's terrible. I'm so glad your electricity's back. That is the worst. It's the worst when you have no electricity. You can't do anything. No air conditioning. No internet. None of it works, right? Back to Dedham doesn't sound good, but we'll see what happens. I mean, how could there be nobody in the NBC 10 chat? Well, I don't know, but it is what it is. They say they're going to have a feed up and there's a camera in the courtroom. Let me go to mass courts and see what the situation is with these documents. Yes, a bunch of motions have been filed in the civil trial. I'm aware. That's exactly what I was just saying. He just popped in. It's in Plymouth. And the motion to dismiss had been filed a while ago. We just couldn't get a hold of it. And so in Massachusetts, what happens is they do not scan all the documents or put them out until both sides have filed their motion to dismiss and then the reply papers, and then they file it all together as a package for some reason. I don't know. It's just the way they do it. I'm in New York. They're in Massachusetts. I have no idea why they do it that way. I also have a 15-page internal affairs report of Proctor, and he makes all kinds of excuses for his behavior, as per usual. I mean, is anybody surprised about that? Not me. I'm not surprised. Are you? Sue says, I'm making a prediction. The judge has had a change of heart on what he's willing to do for the defense. Well, we'll see. We'll see. I mean, Judge Krupp seemed like the first day when we watched Lally get on the stand and be grilled in the Scapicchio barbecue. Everything in the barbecue was seasoned with rosemary. But I'm here all week, folks. I'm here all week. It seemed like he was allowing the testimony. He wanted to hear the testimony. He wanted to hear Lally explain why it took him 4 years, almost 4 years, to turn over basic search warrants that were in his hand during the arraignment for Myles King. And it was good. Then all of a sudden, he had a little change of heart. A little change of heart. Because then the next hearing, Lally and Proctor were in the room with attorneys. And he's like, yeah, you know what? We're not gonna hear any testimony today. No, we're not gonna hear any testimony today. So I don't know. People think maybe somebody got through him. I don't think so. But crazier things have happened in Norfolk County. We've been there, right? We sure have been there. So it'll be interesting to see Judge Krupp's behavior today. And then tomorrow we have Eden Carney's hearing tomorrow in the afternoon at 2 p.m. And we'll be here for that as well. So how's everybody doing? Lally's attorney swayed him. Michael Marcy got to them, says Nancy Joe. Nancy Joe M. Oh yeah, Linda, I did. I watched his Jeffrey Noble is his name, right? Jeffrey Noble's interview with Christina Rex yesterday. It's like 37 minutes long. I was almost snoring 5 minutes in. Except for I did love when Christina Rex started reading him the Facebook comments from the post in which MSP is recruiting. Remember, we looked at that and we were dying over the comments. She read some of the comments to him, and that was gold. That was fantastic. Oh, we're just waiting for
as the Patriots get ready for this.
News 10. It's supposed to come live with this hearing, but who knows if they change their mind. If all else fails, we have the Zoom. So never fear. And yeah, did anybody else watch that? It was 37 minutes long. It was Jeffrey Noble. He's the head of the MSP. He was being interviewed by Christina Rex, who's a local Boston reporter. And it was, abada, abada, abada. A lot of excuses, really no substance. Tell me if you thought anything about that was interesting at all. I don't know why they're talking about the Patriots when they're supposed to be covering this hearing. Let me get the Zoom up. If anybody is on the Zoom, please mute yourself so that they don't hear my voice, because that happens a lot. And then they think it's me who's not muted on there. Please, thank you. I don't know what's happening. It's always something. Always something. Oh, kindergarten cop watched it. He says the colonel believes Karen is guilty, Noble is a puppet, and the rehoming is a smokescreen. Tammy says it was stupid. Not at all. Same old BS. Same old BS. Yeah, Nikki Crayons. Do not unmute and send Mel a bill for your sanctions. Agreed. Thank you. Thank you for that. Well, I don't know. Bigger takeaway from Pat's preseason win over the Commanders. Okay, well, guess they're saying it's good. I guess the Patriots won, so congratulations, everyone who's a fan of the Patriots. I can't believe it's like football season already. Summer's not over till I say it's over. Okay. All right. Cheryl says, let's get the barbecue going. I don't think anybody's going to testify today. I just don't think anybody's going to testify today. Says the host has joined. We will let them know you're here. Put that screen up for a minute. Little change. Little change. Yeah, I saw that Penny McGee was doing an interview with the Boston station, but I couldn't find it. And then I reached out to her to say, oh, you're doing interviews now. Do you want to come on my show? I would love to talk to Penny McGee because we loved following her trial, right? Patriotic says, at least he took it. Well, Elf says, at least he took a stand on Proctor and the rehoming. And Patriotic says, the colonel was handpicked by the governor. That tells you everything you need to know. Who agrees? Disagrees? Faye gifted a membership. Thank you so much, Faye, for your generosity on this beautiful August day. It is really nice outside here in New York. Brigitte says, fingers crossed for a good turnout for Karen Reed. Thank you. Thanks for your 5. Bridget says, love Rosemary. And John Jackson became a new member. Welcome. And Hope says, I'm bummed out that I will miss Aiden's court date. I will be on an airplane heading to California. Well, most of the airplanes have Wi-Fi nowadays. So if you're on Delta, all you have to do is join Sky Miles. It's free. And you can get Wi-Fi. If you're on JetBlue, it's free Wi-Fi for everybody, I think. So you will be able to see it. Don't worry, Hope, but have a nice trip. And thanks for being with me for 15 months. It's gross hot in New Hampshire. Careful what you put in the chat, you guys, because AI, the AI of the YouTubes is getting real smart. And there's a lot of things they don't like. So, you just got to try and keep it classy at the very least. And you can figure out pretty much what words it is that YouTube doesn't like. All right, well, NBC 10 says they'll be right back. Let's see. We'll see. Decorated dude, pickup lines, says he's getting his job back. He'll be out in the Lee Barracks on New York State line where he can get his years sweeping floors. I don't know. You think? You think he's going to get his job back? Sounded to me like Noble said the other day, and listen, I kind of snoozed through that interview. So to be honest, I didn't really pay that much attention, but it sounded like he thought that he did the right thing by firing him. And there was a statement that he put out the other day that it said he didn't think that he was going to get him. He was going to get his job back, that he thought that was, a futile effort on his part. Frozen Tundra says, the judge probably saw Rosemary in the hallway and said, even though I haven't seen your report, it's still not good enough. Court's delayed. Yeah, it's always delayed. I always thought lawyers should be called waiters because we do so much waiting. We're just waiting all the time. Waiting for court to start, waiting for your adversary to get there, waiting for everyone else to get there. It's just waiting. Judge. It's toasty in Florida, says Diane. That's right, Grace. Hurry up and wait. what it always is. Okay, are we going in? We're in. We can get on the Zoom. They always have a better angle because they have a real camera in the courtroom. Let's see who we can spy. Well, is that Jim, the court clerk over here? Let me make it bigger. Let me make it bigger. No, that's Joe Krowski Jr. over there. That is Krowski. Can you see my cursor on your screen? He's got a tan suit on. And you may recognize him from his many appearances on Court TV. He thought Karen Reed was so guilty she should be hung in town square after being stoned by the people. Yes, Judge Canoni did sign off and allowed Karen Reed's motion to get her phone back. I'm going to just put this on mute for a minute. So apparently she's going to be able to get her phones and her car back. Isn't that a long time coming? And there's Clerk Jim walking. He looks pretty tall. I don't know. He may be on like a pedestal back there. Who else do you see? Courtroom's kind of empty. I see Rosemary Scapicchio sitting at the table, at the defense table. Is that Lally in the blue suit with his back to us? No, I think that is the other ADA who's handling this case. That is not Lally. You can hear the captions. It says, yeah, I thought you weren't coming. Larry Tipton should maybe be here because Brian Walshe is a co-defendant here, or a co-party to the Proctor text message issue. There's not been a decision on the unsealing of the sidebars yet. Proctor's lawyer is there. Hello to the Pacific Northwest. I don't think Proctor's going to be here today because I don't think there was supposed to be any scheduled testimony. It says non-evidentiary hearing all over the calendar, so that means no testimony. Right, so that would mean that Lally doesn't have to be there either. This is NBC 10 Boston, yes. Yes, it is. Is Proctor's lawyer on the right here? I think I recognize him from maybe like a Zoom conference with the blue shirt and the blue suit and the striped tie. Is that him? I think his name is Moynihan, Daniel Moynihan. Wait, was that Reddington? My BFF Reddington just walked out. I thought that was Reddington. But I think I said it was Krowski.
I'll take it if you want me to take it. I just don't want to be a situation where somebody says that they gave me something that, you know.
Mike. Okay, the judge is coming. Here comes the judge. Here comes the judge. I didn't know Reddington was involved in this. Isn't that him though, right here, standing next to Rosemary?
Yes, that goes with that one.
This will be Judge Krupp. So this is a non-evident. If anybody comes in and they're like, what are you watching? It's going to be scrolling along the bottom. This is a non-evidentiary hearing on the motion to dismiss day 3. Norfolk Superior, in front of Judge Krupp. I can recognize Reddington's voice.
Court's in session, please be seated.
Oh, thank you. Number two, 19467 Powell versus Bernardo Gel.
Reddington is there for another case.
Okay.
Right now it's on for August 27th.
Yes, we're holding it.
If I could keep it on for that.
Reddington was Jen McCabe's attorney. You're correct.
I'm holding it for trial, so if there's a disposition, it's gotta be before we got a final pre-trial conference scheduled today, right?
Hope they fixed the audio.
I'm sorry, is there a plea? Is there a plea deal? Is there an agreement? Not yet? Okay, so we got trial on.
So I understand that you're drawing a line in the sand, but just so you understand.
It's the line in the sand that you drew.
I don't think anybody's going to testify today, Wendy. I'm talking over court because this is not the case we're waiting for. He said to Reddington, he said, is there a plea? Is there a plea? Reddington's like, not yet. Jim will turn on the mics. This isn't the the case that they want to broadcast, so don't worry. Everybody relax.
27th or 26th?
Don't worry, it's not the case we're here for. They'll turn the mics on and I won't be as loud. And if I'm loud,
Put it on for the 26th.
I will always lower my mic, okay?
So I don't know when that's going to end. I don't know. That's what I'm saying. I'm just trying to do these things.
Can I move the closed captions? Can I move the chat? Can I lower my mic? Can I fix the sound on the court? I'm doing it all. He did. He represented Turk. I can't do anything about the chat. I have no control over where the chat shows up on your device. I'm not a cupcake.
Resolve it and put it on for tomorrow or the next day. But I'm not willing to kick off the trial.
Making his excuses.
This is the 2019 case. I'm sorry?
Is that better? Can I fix inflation? Yes. Yes, I'll fix inflation for you too. I will. I will fix inflation, Kimber. And also I will sing all of the words to Terrapin Station. Terrapin. Reddington is representing no one in the case that we're watching. He's here for a different matter. Everyone's so needy. I know everyone's so needy in the chat. It's so funny. But eventually they get it. If you can't hear, put your earbuds in. But it's not, this isn't the case we're waiting for. Just relax. Everybody needs to relax.
And this is like a drug case that just gets stuck in between.
I am a soundboard expert. I'm going to lower your gas tax. Would anybody like me to pick their children up from the bus stop today? That's why one of the moderators is named Kindergarten Cop. Says Brenda. Brenda says we're the worst, worse than elementary school kids. Okay, this is another case that is not the Myles King case. Can I give you world peace? I would love to do that. I would love.
I believe he's in lockup. Or it could be in lockup. Yes. If he's in lockup, we can also get him there. Okay. You stay right there.
You got it, can't next, Pat. I could be there in like 6 hours. Is that good? What time does she need to get picked up from camp? You got it.
Before the judge is clear. Before the judge, I'll second call.
Coffee? Who wants coffee? How do you take it? How do you take your coffee? I can get DoorDash to come.
There are two custody defendants that are here, Mr. Johnson and Mr. De Los Santos. Mr. King?
Should we try in before we identify ourselves? I think for these purposes also, can I have Mr. Tipton unmute himself? And I would have, at some point, we might ask him to identify himself also.
I will lower your weight for you, Beef Leaf. No problem.
And Kelly Forges, I'm so sorry. And Kelly Forges.
JSMP Jen, I will make you 25 hot skinny.
This is for one case.
Someone speaks, they can identify themselves.
Bring back the fan. If anybody is mean, I'm going to turn off the air conditioning. I will turn off the air conditioning. The co-defendants in the Proctor matter are, in addition to Myles King, Bianca Chinocchio, represented by Joe Cataldo, Giovanni De Los Santos, represented by Joe Krasky Jr., Sean Johnson, represented by Rosemary Scapicchio, Larry Tipton, represented by Brian, Larry Tipton representing Brian Walshe,
Okay. Can I have Commonwealth identify herself in general?
Okay, so just for the record, we have this case is Commonwealth versus Myles King, 21-320. We have Bianca Chinocchio, which is 22-265. Giovanni De Los Santos, 22-267. And Mr. De Los Santos is here.
Here.
Right here, Judge, in the white shirt.
We have Sean Johnson, 22-268. Mr. Johnson is present.
He has a purple shirt.
And we have Brian Walsh, which is 23 CR 91. And I think those are all the cases that we currently have on our docket for today.
It's not clear to me if Mr. Walsh is present on Zoom or if he's present today.
First of all, the sheriff's office is there.
Why are you buffering? I'm on Ethernet. It's on me. Oh, are you kidding me?
First of all, the sheriff's office is there.
The spinning wheel of doom. Oh, it's them. All right, let me try the Zoom. Please mute yourself if you're on the Zoom. That's ridiculous. They just ended it? Can't make this up. Can't make it up. They just ended their Zoom. I mean, they just ended their feed. We're going to hell in a bucket. I know. Walshe is appearing by Zoom, I believe, today. Did they change their mind about wanting to live stream it? Yeah, they're buffering to prevent us from hearing stuff. Hold on.
As well, if necessary, with a protective order, and that we would ask the court to endorse it, and then we can provide those chats to counsel. We are aware that defense attorneys are taking the position that the Norfolk District Attorney's Office needs to review the additional materials, the materials that have not been provided outside of the protective order to the Norfolk District Attorney's Office. And with that knowledge, that their position that we need to do that, we have taken the additional step of filing a motion to intervene and seeking relief from Judge Casper. That was done today. We filed under seal, given our understanding that it's not a public docket at this time in the federal court.
You have a copy of your filing for the court to review.
I do not at this time.
Have you shared it with defense counsel?
We have not.
Okay.
I can tell the court that we are making requests, including asking permission for the Norfolk District Attorney's Office or outside counsel to review the materials. And we are also asking that we, or in the alternative, we are asking that we be able to retain the materials so that the defense attorneys can pursue their own avenues of obtaining the materials through Freedom of Information Acts or the 2E process. We've reached an agreement with the U.S. Attorney's Office that our filing tolls the return and destroy date, and we have...
Judge Casper agree with that?
I don't know that she's seen our filing at this time. I don't know what her understanding is.
When the U.S. Attorney's Office agreement is no good, well, it's what Judge Casper thinks her ruling means.
And so what I'm telling you is based on the representation from the U.S. Attorney's Office and absent a ruling from Judge Casper, at this time, we will not be returning or destroying the document. So as the court, I'm sure, is aware,
if I understand correctly, Judge Casper's ruling runs until the 17th of this month, so that falls on a Sunday, so it would fall on the 18th of this month. You filed today?
Yes.
Which gives us a 5-day window, basically, or 6-day window. If Judge Casper doesn't agree with your tolling idea, well, if she doesn't agree with your tolling idea, that's a real problem, right? Because that means things expire on Monday and have to be destroyed or returned on Monday. Under her order, and if she does agree with your tolling and then ultimately doesn't extend or doesn't makes a decision on the merits of your motion and doesn't allow you to intervene or whatever it is, then we only have 5 days. If she agrees with tolling and doesn't agree on the merits, you only have 5 days to do whatever I might order, and we don't know when she's going to act.
Your Honor, the last time that we were in a somewhat similar procedural posture when the U.S. Attorney's Office filed their motion, there was no disagreement that the filing of that motion told the order.
Mm-hmm.
So that's why I feel reasonably confident that we can anticipate that we will be able to litigate this matter in the federal court. But regardless of that, I want to be clear that we have obtained additional materials during the time period that we've been working on this. And certainly, as outlined in the letter, the most substantive and relevant and probative issues to our Rule 14 obligations.
Okay. So that's the current status from your perspective.
That's the current status
Okay.
from our perspective.
And what are you asking me to do?
So I'm asking you to take no further action with regard to the global matters. I understand that there are individual defendants who are asking for the court on their individual cases to make particular rulings. I know that there's at least one filing in one of those cases. And I think that you could, I don't know whether or not the courts had the opportunity to review our opposition. I think we filed.
You're talking about the Walshe matter, the motion to dismiss in Walshe, and your response. I did receive both and read them both. So you would have me take no further action and schedule no further hearing? Or do what? I mean, what do you think I should do in terms of schedule, given what you filed with Judge Casper? Do you know if she's around, if she scheduled the hearing, if she, do you know what her schedule is?
I can tell the court that we only very recently filed. So
Okay.
I don't think it's realistic to think that she's aware of our filing or has any intention at this point in time as we are speaking.
All right. I mean, I'm a little hamstrung here because I was encouraging you to do this weeks ago and encouraging the defense counsel to also seek to intervene in the proceeding, a while ago, and it only happened now, and we have a very short amount of time.
I understand that, but I do think that we've achieved an awful lot during that time period. And so it wasn't wasted time. And I think that what we have obtained is probably was more efficient than handling it in any other manner, quite frankly. And I don't know what defense counsel's position is at this point in time. I don't know whether or not any of them has filed any pleadings in the federal court. But if the court wants to pick another date, we can do that. But I don't think that it's necessary to continue on the week by week kind of path that we have been on.
If I don't continue a week by week, as soon as Judge Casper rules, we have a 4-day or 5-day window. I suppose I could enter an order today, which is contingent on what Judge Casper might do. There are a lot of things I could do, but it would be very if this, then that, which is problematic for me in fashioning a suitable remedy.
I understand that. I do think that, and this court is aware that there are, that the federal law is significant in this regard. But
so is the state law. And regardless of what the federal law says or doesn't say, you've had custody and possession of these records for more than a year. And this is, we've talked about this already. It's at the very end of the time that this is all coming to a head. And leaving aside the question about whether you control the records, which is the operative language in a lot of the filings, you clearly have possession and custody, and that's what the feds are worried about. Rule 14 says what it says, and our constitutional interpretive case law says what it says in terms of the obligation on prosecutors to review and disclose that type of information. So the court has significant remedies available to it, and that don't involve ordering you to do something in violation of the federal law, okay? But there would be consequences on you and your prosecution of these cases if you did not comply with your state constitutional requirements or your Rule 14 requirements with respect to the material that's in your possession and custody.
But that's why we're acting in the manner in which we're acting, Your Honor. And I want to be clear, as the court now is aware, the order itself prohibited this discussion prior to only recently.
I don't know that. You've given me a December 2024 order. I don't know what was in place in February. I don't know what I think there was a date between February and December where there was another order. I haven't seen those orders.
So I
don't know why you can't give me a copy of what you filed with Judge Casper or give to defense counsel, to be honest. The fact that it's a sealed proceeding, it doesn't mean that you have to file everything, you have to keep everything that you file in that proceeding under seal.
I'm relying on the advice of our counsel, and we have repeatedly asked for those previous orders. We have been told that those previous orders substantively are identical to the most recent order, that the reason there were multiple dates was if they provided for different people to sign the acknowledgement. That's all the information that I have.
Have defense counsel sought to subpoena the information from defense counsel in the Reed case? Because all of it was turned over to them.
I did speak to one of the attorneys in the Reed case, Your Honor, asking for that information. It was that attorney's position that the document was under seal and that they couldn't give it up voluntarily. And they didn't know what they would do in response to a subpoena. But that's the information that I got from the judge.
Okay.
They don't think that they think that they're bound by the order that they signed.
Okay. Well, all right. Well, you didn't subpoena them. It's not framed. It's not, the issue is not joined. The issue.
If we have a new hearing date, I'm happy to subpoena it.
Mm-hmm.
But I don't have a subpoena for this court date because I thought that might be an abuse of the subpoena power because we weren't going to actually.
No. I agree with you, but we were not going to have evidence today. All right. Well, let me hear from defense counsel as to what one or more think I should do.
So, Judge, on behalf of Mr. King and Mr. Johnson, I'm asking that you take action on our underlying motions that we filed for relief regarding the federal materials in possession of Commonwealth. I'm very concerned that we have 5 days. I was concerned when we were here last time that time, the clock was ticking. I know the court was concerned. I know the Commonwealth was concerned. But the bottom line is that if this doesn't go the way the Commonwealth anticipates it will, then these documents are gone forever and we'll have to file additional motions as to what the court can or should do under those circumstances. So we're asking the court to act on our motions in order the Commonwealth to review the evidence that they have in its custody. In the alternative, we're asking that if the Commonwealth declines to do that or the court declines to enter such an order, I'd be asking the court to dismiss the cases against my client because he cannot get a fair trial without the opportunity to review and analyze the information that's been in the possession of the Commonwealth since February of 2024.
Okay.
Judge, Attorney Krusk on behalf of Giovanni Della Santos. Just one suggestion, is there, having practiced in federal court and still currently practicing in federal court, is there any reason that the government cannot make a call to Judge Casper's session clerk right now and find out whether or not it has been docketed and whether or not there's been a hearing order?
I'm sure it was filed by Pacer. I'm sure it was on Pacer and it's been docketed. There's a representation already that it's already been filed, but obviously I would like to know when Judge Casper is likely to see it and review it. She may be on a 2-week vacation hiking in Nepal. And so I don't know.
And that's sometime, I just know anecdotally and empirically, that's information that the session clerk might be able to reveal that it's being reviewed. I understand the position that going forward, we don't need a court date every week, but certainly the posture right now, I think we need a weekly court date. So I think that
I agree with that. And I'm surprised the U.S. Attorney's Office didn't join in a 30-day extension. What's troubling to me is the U.S. Attorney's Office's position in the letter to Attorney Beatty that they're not going to seek a further extension or further amendment of the protective order. So they seem to be saying we've done as much as we're going to do. Now, the information that Attorney Beatty is sharing with us now, or sharing with me now, maybe you folks knew before, that they've agreed to tolling. And again, we don't know whether Judge Casper is going to agree with that, but they've agreed with the idea of tolling, even if it's not an extension, just means we have that 5-day window that's preserved. And so that informs me about when I need a next hearing, unless we can get further confidence that we're going to have enough time to deal with this.
well, I think we need a hearing on or before Monday. Just so it's clear on the record, on behalf of Mr. Della Santos, I'm joining the request that all Rule 14 discovery in the possession of the District Attorney's Office be turned over to Mr. Della Santos, irrespective of any other order from any other court immediately.
All right. Any other counsel wish to be heard? Mr. Cataldo?
Yes, thank you. I think we need another date before the federal court, once they act as Judge Casper acts. We need another date, a short date. And I think it goes without saying, we should order the district attorney's office to comply with Rule 14 and go through all of it and meet their obligations to us.
I don't need to order the district attorney's office to comply with Rule 14. They have that obligation already. They already have the obligation under Giglio and Brady and related cases to produce information in their possession and custody, which are exculpatory.
They're complying with that.
Well, that's a question that I have. Okay, that's a question that I have in connection with the Walshe filing with respect to the opposition of the motion to dismiss in the Walshe filing, and we'll get to that. But I don't need to enter that order because that is already their obligation.
Can I just make a couple additional points?
Yeah, I was thinking I might hear from Mr. Tipton before, but go ahead. I hear you, and then I'll hear from you.
I think Ms. Cusick is going to represent the Commonwealth on the Walshe case.
Okay.
She had filed the pleading that's more specific and responsive to the multiple pleadings in the Walshe case. So,
Okay.
I'll let her chime in at the end, but I do want to note that defense counsel is orally moving to dismiss. The Commonwealth is not on any notice of that, so I would ask you not to take any action in terms of dismissal at this time. I also would note that no counsel has cited a case that outlined this particular procedural posture and how it interplays with Rule 14. And I appreciate that the court is saying that you don't need to order us to comply with Rule 14. And I don't mean to be disingenuous when I say you don't. We take this seriously.
No, I understand that, and I'm not suggesting that otherwise. I'm really not suggesting otherwise.
Defense counsel isn't either.
Yep.
But this is a big deal.
Yep.
What is being contemplated here, and to throw these sorts of terms around these are important issues for the defendants. These are important issues to the Commonwealth, to the victims, and to our whole process. And this office is committed to and is continuing to work through these issues.
And I appreciate that, and I appreciate the way defense counsel has handled it, and that's the reason why I'm taking it in sort of an incremental way. I understand the sensitivity of it. At the same time, I'm trying to get us to a point where it is a non-issue, okay, where we can be satisfied that the documents, that we don't have to parse control versus custody versus possession, okay, and what that means under Rule 14 in this particular kind of a case. Because I'm not sure that there are cases that we'll find, certainly not in Massachusetts on this topic, and certainly not under Rule 14 as it's been recently amended. So I think we need to know what next steps Judge Casper takes, and we need to respond accordingly and give Judge Casper the opportunity to address these issues, understanding their sensitivity.
Can I just respond briefly? Sure. I know we talked about, at least the Commonwealth talked about a response that they made in the Walshe case. They haven't responded to either of the motions that we filed on behalf of Mr. King or Mr. Johnson. I don't have a copy of their response in Mr. Walsh's case. So to the extent that they've known about these motions since they were filed back on, July 18th, 2025, they've yet to respond and oppose it in any way. And now are we supposed to, the defendants in this case, are supposed to keep track of what's going on in Walshe to know the Commonwealth's position?
I understand that particular predicament, and I am happy to set a schedule for the Commonwealth to respond to your motions. I don't think I'm prepared to address the Walshe motions just yet, but I want to hear from counsel on them. The issue that I raised, that I had a question on, I'll see counsel on the Walshe matter if they wish to address the court separately. Mr. Tipton and Ms. Porges, I think you're up. I have a motion to dismiss or request for alternative relief. I'm inclined to go gently on this issue and see what Judge Casper does in terms of either giving us additional time to consider this. Let me just ask again, Ms. Beatty, to say exactly the relief that was sought from Judge Casper. One, besides leave to intervene, what else did you ask for?
We asked for modification or a court order that would permit the Norfolk District Attorney's Office or outside counsel to review the materials. We also asked that we be permitted to retain the materials for a period such as 6 months so that defense attorneys could pursue their own avenues of obtaining the materials. And I just have 1 minute. We asked that the court toll the destruction date in the protective order until after the issues, bless you, until after the issues raised in the motion are fully resolved. And as I said, we asked for oral argument. And I'm happy to ask our counsel whether or not we can share these pleadings, but I'm not prepared to share them at this time.
Did she say she just filed that motion today? Somebody remind me.
At the appropriate time, Judge, I'd like to be heard briefly.
Yeah, hang on 1 sec, Mr. Tipton. So the second to last paragraph of the first Assistant U.S. Attorney's letter, dated August 5, says, in the United States' view, it would be inappropriate for the Norfolk County District Attorney's Office or Defense Counsel in the other matters to seek to intervene in the U.S. District Court matter and to move to amend the protective order.
Yes.
That sounds like, other than the agreement with respect to tolling until Judge Casper can decide what she needs to decide, you're going to be faced with an opposition by the U.S. Attorney's Office to your motion to intervene.
I agree with that assessment, Your Honor. And we took the steps that we took, notwithstanding the position of the U.S. Attorney's Office, and we reached the tolling agreement after this letter. So my point that I'm trying to make is, notwithstanding their substantive point, I do not think that they are trying to put this court or this district attorney's office in the position of violating either a state court order or a federal court order.
Okay. Mr. Tipton.
Thank you, Your Honor. I mean, I heard you say you were...
Hang on 1 second. Can everybody hear Mr. Tipton? I have difficulty hearing him. Well, hang on a second. Let's see if Mr. Tipton can adjust things on his end so that he can be heard better. Maybe you can increase the microphone or...
I just did. Can you hear me now?
A little better.
I'm practically yelling here, so I'll keep yelling.
No, I really can't hear you, Mr. Tipton. I'm sorry.
Maybe I should try to join using a different computer real quick, but I don't want to waste the court's time.
I'd rather hear you.
Judge, can I make a suggestion?
What's that?
Mr. Tipton calls my cell phone, I can put it on speaker and everybody can hear.
How would that be?
Fine with me.
Okay, do you have, I don't need to ask you specifically, do you have Ms. Scapiccio's cell phone number?
I don't think so.
Judge, I can share it with Mr. Tipton right now.
All right, very good.
And I'll call in.
Or I can just call you right now.
You can call me.
Mr. Tipton, this is Jim McDermott.
Go ahead, Jim, try that.
Sure.
Look at Jim taking the reins. Jim is taking the reins.
All right. Well, here you are.
Can you hear me better?
Hang on one second. Why don't you identify yourself for the record?
Larry Tipton from Walshe.
You able to hear that? All right, Mr. Tipton, we'll hear you.
Just briefly, Judge. I think Liebman, whether it's the government opposes it, but Liebman seems to make it clear it's the Commonwealth's obligation to get materials from the federal government. There's no question when you read those two cases that is exactly what the SJC said way back in the 1980s. Secondly, the Commonwealth has failed to inform this court or any part of it what the exact basis is that they're relying on that says they can't review the documents in their possession and custody for Rule 14 information as defined by Rule 14. Now, I'll just say that when we were in Plymouth, they produced a December 2024 protective order. There was one they let us read it. We couldn't copy it. We had to hand it back. We did. There is a paragraph in there that seems to touch upon the issue at hand. But that paragraph, and I won't repeat it, but I think the government knows what paragraph it is, and it does not, in our opinion, prevent the government from reviewing the documents under Rule 14. It does have language that says you can't use the materials in any other case other than the read matter. But that's not what we're asking for. And for the government to continue to act like a paragraph that says you can't use materials in another case means they can't review them under their obligations under Rule 14 is creative thinking, creative interpretation, and it's simply running away from their obligations. And finally, the only other thing I have to say is what we've said repeatedly, and it was based on what the government told us beginning on July 17th when this issue became known. And that is, why haven't they explained then why Attorney McLaughlin, Assistant District Attorney McLaughlin, did in fact conduct some type of review of these materials and gave certain information to either the prosecutor in their office and our defense counsel. Now, granted, I was never told they gave substantive information, but they apparently gave sufficient information to either their DA or the defense attorney. And that is not addressed, once again, in the government's opposition today. And I have argued that since I was told that on July 17th. And I'll just add that when we were before Judge Ferner, and she read that, and I understand that she cannot rule on this issue because of a judicial conflict, but she confronted the Commonwealth about that very issue. And the government refused to answer. And so I asked this court, why can't the government simply explain that? Why they did it in one case, why they provided information to either their DA or defense attorney in an unrelated case, and why are they simply refusing to do so now based on language they have not produced that, in my opinion, would not justify anything, but they still not produced the specific language. So I understand the court's not going to rule on our motion to dismiss today, but the last thing I'd say is I hope that this court will schedule some type of status hearing no later than next Thursday or Friday. And if nothing else, order the government to stay in touch with the federal authorities and have an immediate update about the status of their motion to intervene. And that's all I have right now, Jim.
All right, thank you. Mr. Tipton, are you connected? You can hear us through the regular Zoom, is that right? I see you nodding your head. Okay, very good. If you want to make another point, jump in and we'll call you again. But I don't want to cut you off. I appreciate the positions. It does seem to me we need another hearing, informed to some extent by what Judge Casper does. Is there other counsel that wish to address the court? I do have one question for defense counsel in the Walshe case. Who's speaking on behalf of the Commonwealth in the Walshe case?
Your Honor, Tracy Custer for the Commonwealth on the Walshe case.
All right, so I have your response to the motion
Your Honor, a bit of housekeeping, if I could. That was a response to other motions. We received Mr. Tipton's motion to dismiss.
No, I'm sorry, I misspoke. This is a response to the motion for relief regarding federal materials. It's not a response to the motion to dismiss. But in your response to the motion for relief, you say the Norfolk District Attorney's Office is aware of its obligation under Rule 14. It's one of the last lines in your opposition, but you do not say whether you have or haven't complied with it. So I really don't know how you're interpreting Rule 14. How are you interpreting Rule 14?
Your Honor, we are interpreting Rule 14 as it is written, as we understand it to be written, that our obligation is to produce materials favorable to the defense, that our obligation is to, if we're aware of them, to inform the defense of those materials. We are aware of our obligations under Rule 14 in this matter, Your Honor.
But that doesn't really answer my question. We have unique circumstances here. Is it your view that even though these are nominally controlled by the feds, that you don't either possess them or have custody of them?
Your Honor, it is our view that doing what counsel is asking would be violating a federal protective order.
Reviewing the documents would violate a federal protective order?
In conjunction with a different case other than the Reed matter. In this case, we do have the unusual circumstance of someone assigned to the Reed matter is also assigned to this matter.
McLaughlin.
And
so your position is even reviewing the documents, reviewing the documents in this context is not required by Rule 14?
Your Honor, I believe reviewing the documents in this context would be a violation of a federal court
But that's
order.
a different question. The question is, does Rule 14 require you to review these documents?
I don't believe it does, Your Honor, in the current posture of this matter.
And is there anything you can cite to me that would support that position?
At this point, Your Honor, I would say there is currently a federal protective order. We are officers of the court. We are required to comply with that order. And I would suggest it is clear there's the balancing of that federal order and the Rule 14 requirements of which we are aware. In this case, I don't know if the court had a chance to read in detail the Commonwealth submission.
I did.
There have been prior to requests by both the government and by the defense in this matter. And again, the court has the response we received from that as well.
The TUI request, though, is a different question than whether the Constitution, Massachusetts Constitution or the federal Constitution or Rule 14 imposes on your office an obligation to review documents that you're in physical possession of. And I don't really, I know that, I don't want to say I don't care, but it's not particularly material to the question of what the Constitution requires of you that a federal prosecutor somewhere said, I wouldn't give it to you independently.
I understand that, Your Honor. At this point, I don't believe we are required to review those materials in violation of the federal protective order, but certainly I would ask for some time to respond to the motion to dismiss that was filed this morning.
Yeah, sure.
And again, if something, for example, if something was in plain view, that might be something that would cause a person reviewing those materials in the Reed matter to bring that to the attention of the federal authorities or to others to say they're aware of information in the custody of third parties. Certainly nothing like that has occurred in this case. No one has indicated they're aware of any materials in the possession of third parties.
Okay. I'll give you an opportunity to address the motion to dismiss. We'll play this out a little longer and see what happens with the motion to intervene and motion for additional relief. I may issue an order in response to this argument, explaining why I'm doing what I'm doing. And I'll schedule a hearing for, I think, early next week. I could do the end of this week too. I'm here, but I think the early next week is probably enough time.
I think the order expires on Monday.
The order expires on Monday. That's true. So maybe we should do it before the end of this week.
Could we do Thursday, Judge, potentially?
I have that flexibility, and we should know more from Judge Casper by then.
I could do Thursday morning if anyone could do Thursday morning.
This week?
Oh, Thursday afternoon, sorry. Thursday afternoon, yeah.
I'm on trial.
I could stand in for you, Joe, if you want.
Okay.
Thursday afternoon? Yes. Yeah, Thursday afternoon at 2 I could do if I'm just trying to give us some time.
Yeah, yeah. I'm flexible given what everybody else's schedule is. I think 3 days is probably enough time to get a read, or 2 days. It's only 2 days, but get a read from the federal court as to when they're likely to address the issue.
Not do Thursday, Your Honor, but Attorney Scapicchio can stand in.
I'm happy to stand in.
Okay. Mr. Tipton, with a thumbs up or thumbs down, are you able to do Thursday at 2, even if only on Zoom? That's a thumbs up. Okay, Thursday at 2. Thank you. Attorney Beatty, what do you think?
That's fine, Your Honor.
Thursday at 2?
And Judge, in the interim, may we get a copy of the Como motion to intervene?
I'm not prepared to provide that at this time. I will consult with our counsel, and if he advises us that it's appropriate, I can do that.
At a minimum, I would like a copy shared with myself and all counsel, even if the content of any confidential information or confidential material has to be redacted from that filing. So I don't know if in your filing, because you're obviously privy to the confidential information, not necessarily you, but others in your office are privy to confidential information.
Not the reason that I'm not sharing it. There's
Okay.
nothing in there that's confidential. That's not the reason.
So if the only reason is that it relates to an impounded proceeding in the federal court, the fact that it was filed in that impounded proceeding, I don't believe entitles it necessarily to be impounded for all purposes.
Again, I'm going to rely on the advice of counsel.
I'm not suggesting you do anything else, and I'm not ordering it to be disclosed right now. I'm taking your representation as to what relief it seeks, and we'll deal with this again on Thursday at 2.
And I think the other concern would be that if we shared it with counsel, what would they do with it as well? I think that's the...
Well, I think we're trying to keep apprised of what's happening in the federal courts so we can make decisions most intelligently here, and so that I don't do anything rash.
No, I
so,
appreciate that. I would ask for an agreement that it not be shared or disseminated outside of council. That's what I'm saying.
Every piece of paper that's been generated in this issue has had a check of order. We don't have a problem with that, Judge.
okay.
No objection on behalf of Mr. Dela Santos on that limited discrete issue.
Okay, and with respect to, so that's Mr. Cataldo?
Okay.
All right, any problem with that, Mr. Tipton?
No problem.
Yes, no, he's shaking his head no. Okay, very good. In the Walshe matter, I have the Commonwealth's motion for protective order, August 5, production of chats, and Commonwealth's motion for state court protective order covering materials subject to federal court order. Those were signed by prosecutor and defense counsel. I've allowed them and issued them as so ordered, so.
Yeah, I'm also submitting for Myles King and for Sean Johnson as well. That's been endorsed by both parties.
Okay.
And I will.
I did make one amendment to the King and Johnson on page 3 in that paragraph saying, because the Commonwealth agreed that I could share the information with my clients, but not the actual document. You can't get a copy of the document. So I made that change on that. I just want to bring to your attention, Judge.
Ms. Hickman, did you see that?
We did, and ADA Beatty saw it as well, and we are in agreement with that language.
Okay, so it would read, let's see.
The defendants are able to view the chats, Your Honor, but they just cannot get copies of the chats that are being produced.
Not duplicate or provide a copy of the text messages to any other person.
Correct.
Okay.
And Your Honor, I will get the printed for Mr. Cataldo and for Mr. Kowski, and I'll submit them by the end of the day so they can have their text message, the chats as well today.
I'm prepared to sign one subject to the same modification, Judge.
Okay.
It was emailed to me, but I was already en route to the courthouse.
All right, let me just act on these with respect to Mr. King and Mr. Johnson.
And I just had one issue I wanted to address before we conclude.
Sure.
I'm not going to be here Thursday on behalf of Mr. Dela Santos, but just so I'm clear of the landscape, I know we're keeping it a short day so we get a better appreciation of what's going on in federal court. But if I understand this court correctly, are you also contemplating an order that would order the Commonwealth to begin reviewing those materials for potential Rule 14 information?
Right now, I'm contemplating an order that explains why I put this off 2 days. I may have time to do that today, and I may not. Maybe not till tomorrow, but I am. So we'll see how far I get on that.
All right.
Okay, but in any event, we'll have further hearing on Thursday. Okay. Anything else?
Thank you, Mr. Clerk.
Okay.
There is a protective order on Mr. Dela Santos related to promises and rewards and inducements.
That's with a different DA.
Okay. Joe, just before we conclude, I wanted to address that today, right?
Yes, okay.
Oh, great. You just filing this, right?
Yeah.
All right. Can you just identify yourself for the record?
Good afternoon, Your Honor. Jennifer Player for the Commonwealth.
Okay. And this is in the Ciancio, Dela Santos, and Johnson matters.
Yes, Your Honor.
Okay.
Good afternoon again, Your Honor. Rosemary Scapicchio on behalf of Mr. Johnson.
Okay.
Your Honor, the Commonwealth.
Hang on. And Mr. Krowski?
Attorney Krupp on behalf of Giovanni Dela Santos.
All right.
Attorney Joseph on behalf of Bianca Ciancio.
All right. And on each of these three cases, I have the Commonwealth's motion for protective order regarding witness identifying information.
Yes, Your Honor. The Commonwealth became aware the week before last in speaking with a sergeant from the State Police Violent Fugitives Unit that there was an individual that was involved in assisting them in the apprehension of Mr. Johnson, who they were unable to locate for approximately 8 months after he was indicted. And that sergeant indicated to the Commonwealth that the individual that assisted them with information was given a reward for that information, a monetary reward. The Commonwealth asked the Sergeant for the particulars surrounding the circumstances, who the person was, identifying information, how much money, et cetera. We asked them to reduce it to writing. That was done. It was provided to me yesterday afternoon, and the Commonwealth is prepared to provide that information to counsel. However, contained within the information is the fact that that individual is in fear for their safety if their information is to be disseminated to individuals other than the attorneys, and therefore the Commonwealth is asking that the information be provided under a protective order and limited to the information to the attorneys themselves.
Okay. You've seen these motions?
Yes, Judge.
Okay. Is there an opposition to the motion?
I do object on behalf of Mr. De Los Santos.
Okay.
I would, subject to the court's approval, meet them halfway. I think that my client being charged with with homicide is entitled to know who is accusing him or so-called co-ventures of what. I, at this time, would agree not to share the actual hard copies of the paperwork if there's any concern about dissemination with any facility. However, for him to prepare for his own defense and participate meaningfully, he has to know who's accusing him or his co-defendants of certain conduct. I would imagine that the government, and they're being tried together, is going to try to use this information as potential consciousness of guilt. That name probably will mean nothing to me, but might resonate with my client. It might be a person that he has problems with. It might be a person that he has specific firsthand information of as it relates to bias or credibility. And again, if you look at the pleading, it is deficient in that it's only a very generalized assertion that the witness has fears for their safety. I would imagine, having done these cases for many, many years, that if you poll just about every civilian witness in a first-degree murder case, they would express some sort of generalized concern for their safety. There's nothing laid out in affidavit giving an individualized, particularized assertion of why they're afraid for their safety as it relates to Mr. De Los Santos. So again, in the spirit of compromise to move the ball forward and have my client, who's got idle time on his hands, participate in his defense, I would agree not to share the actual documents with him, but I would ask that you allow me to bring the documents and review them with him when I meet.
So I join in what Attorney Kowski says, but I have a bigger issue, which is another issue we're dealing with in a separate case, but where has this information been for 2 years? How did the Commonwealth just get it last week or the week before? How have they not gone through the file and determined what evidence they have? Why are we just finding out about it now? And that's my concern, Judge. So I'm going to ask that you order the Commonwealth to file specific compliance in the Johnson matter, so that we are sure that we have all of the information, that the Commonwealth has done their job, that they've met with these people, and that we're not going to keep doing this where we can't schedule a trial date until we have a certificate of compliance to understand what's going on here, Judge.
I would join that request and ask that it lay out specific dates of when each piece of discovery was turned over.
Attorney Cataldo?
Yes, I too object, Your Honor. I think the defendants are entitled to know who their accusers are and who witnesses are and who people, informants might be in a circumstance like this. To the extent this court were not to allow it, I'd ask the court to at least do it without prejudice, so that after we find something out about these individuals, we can come back before the court to then see if that's something we should share with our clients. Because ultimately, it is our clients who may or may not know these individuals and may or may not know the relevance of these individuals to the case and to the defense.
All right.
We shouldn't be operating blindly.
Attorney Blair, defense counsel, giving you a range of other options you could fall back to.
Your Honor, what I can say is that it is put forth in the motion. The state trooper did speak to the individual who expressed their concern. And Your Honor, this is a witness who assisted in locating Mr. Johnson. It is not, this witness did not make any statements about any of the other co-defendants or about any of the merits of the case, just merely the location of Mr. Johnson.
How do we know that?
Oh, the, how do I not allow counsel to communicate with their clients about a witness who's going to be testifying or might testify, or they even might call to testify with regard to a matter relevant to the case?
Well, Your Honor, the Commonwealth will not be calling this person to testify. It was 8 months after the case. It was merely a location. Your Honor, I would submit that that counsel could review the information. The Commonwealth will not be calling this witness. Counsel can review the information, and if they determine that this is somebody that they would want to call, they could come back to the court and ask for the order to be modified. The Commonwealth is concerned that there is a significant safety issue for this individual if the identifying information is revealed to their clients.
Judge, I guess I'd ask with respect to Mr. Johnson, what's the safety issue? Other than generally he doesn't want anyone to know that he got paid to give up Mr. Johnson. I understand. That's not enough of a reason not to allow Mr. Johnson to investigate this, because what if it affects 4 other witnesses in the case? I don't know that, but I don't want to be in a position where I have a trial date and I'm finding out on the eve of trial that this witness, who they said was nothing, ends up being way more than that, Judge. We can't make that determination without sharing the information with our clients.
The witness assisted the state police in locating the defendant years ago, right?
Yes.
The promise, reward, or inducement was paid to that person years ago.
Yes.
So all of this information should have been turned over to defense counsel years ago, right? Presumably, you know, that's the first promise, reward, and inducement paid by the police in connection with this case, presumably. I don't know, maybe there were others. And there's no suggestion that there's been any issues with respect to this person. May not be known to the name, may not be known to the defendants. Or maybe the defendants have had some suspicion, or Mr. Johnson has had some suspicion but hasn't known who it was who called the police about his location. I don't know. Where was Mr. Johnson apprehended? California.
No, New York.
New York?
No, he was not. No.
In Massachusetts?
In Massachusetts, in Webster, Massachusetts.
In Webster, okay.
Sorry, Judge, I apologize.
All right. All right. Okay. I'm going to allow the motion for protective order, except that the name of the person can be shared with the defendants. Any documents containing the name or address or other identifying information, that any written documents, okay, will not be shared, but the name can be shared with the defendants.
Thank you.
So these motions will be allowed, except that the name can be shared orally, okay, with the defendants. And that will be without prejudice to renewing a request for further disclosures if necessary.
Thank you.
I did the one full screen. He's getting everything. He's getting all the info for his inmates.
want to hate your claim.
All right. Now, anything else that we need to do on this cluster of cases? This 3 Code D case or the others?
I would just ask on behalf of Bianca Ciancio that she'd be excused on Thursday. Attorney Scapicchio is standing in. She's out on cash bail.
I'm happy to have any of the defendants who wish to be excused on Thursday. I don't know if either of the defendants who are here in person want to be brought in again. I know it's a hassle to be brought in, but if you want to be brought in, we'll bring you in.
It seems to me they both have said yes.
They both, yes.
Santos wants to be.
Okay, Mr. Johnson would like to be here.
Okay,
And
fine.
Mr. King is out on bail and he'll definitely be here.
Okay, very good.
One last issue.
Yes.
I had filed motions last time with the court, and he was then subsequently interviewed by probation. Sure whether or not he qualified.
All right.
And you were just waiting
on
authorize those motions subject to that interview and evaluation.
Have that information? Okay. All right.
De Los Santos?
Yes.
I'll take a look at those motions for funds.
I'll look too.
Okay.
Maybe.
Thank you.
And then just do a separate matter with Mr. King.
That's correct.
Yes, we do.
Judge, just while I'm waiting for everyone to come in and out, Christopher Rando, Mr. Nelson, and Mr. Amanu.
Okay, thank you.
Thank you. It's on for, Mr. Rando, you're good right there. Could I just have counsel identify themselves for the record, starting with the defense attorney?
Good afternoon, I'm David Arnold, John Nelson for Mr. Rand.
Thank you.
He's present in the back. Sean for pretrial conference.
Sir, you can be seated. Okay.
So, and speaking, I believe I have all the discovery other than the drug file.
Okay, so we're just waiting on that.
We're going to request the date of either the 14th or 15th of October for pretrial hearing and filing of any motions. I think we could.
Do you anticipate any motions?
Maybe a motion suppression.
Maybe.
It was a motor vehicle stuff.
Okay.
I think 10:15 works better, if that's okay. 10:15 at 2
Is that okay with you, Mr. Amanu?
Okay.
Great.
Thanks, 2 p.m. Thank you.
Thank you.
October 15 at 2.
Thank you.
Thank you for your patience.
Thank you. Thank you.
Thank you. And now we're back on the Myles King matter.
Thank you.
Good afternoon, Your Honor. Michael McGee for the Commonwealth.
Okay, Mr. McGee.
Good afternoon again, Your Honor. Rosemary Scapicchio on behalf of Mr. King.
All right.
Good afternoon. Nicole Scapicchio on behalf of Mr. King.
Okay, Mr. King is here.
Good afternoon, Your Honor. Dan Moynihan on behalf of
Mr. Moynihan.
I filed that amendment motion late this morning.
I saw that, yes. So I was given a piece of work product, page 1 of 36,
Correct, Your
which
Honor.
looked like well, you tell me what it is.
So, Your Honor, you gave us, or counsel, 2 tasks. One was to provide a list of all new discovery and any disputed, whether it was new or previously provided.
Yep.
In a joint form. That is what you have before you. You also asked counsel to identify which of those documents were exculpatory or items and information favorable to the defendant that you do not have.
Okay. So let me just see if I understand this correctly. And I didn't have a chance to compare this earlier against the notices of discovery, but let me just take a look. So you start with notice of discovery 26, and these are numbered 1 through whatever it is, 8, because there are 8 things in the notice of discovery 26. You've listed the description, which is the same description given in the notice of discovery, as best as I can see. And then there is an agreement on the right-hand side. If it says why, you both agree as to defense notes, which was that was not previously produced. Okay, if there is a no in that last column, it indicates that.
Oh, really? Now they're gonna cut us off? They just ended the meeting? Okay, that's not cool. Did NBC 10 come back with it? Because they were only on for 20 minutes and then they went off because they knew that they made a mistake in titling their video because they said Michael Proctor expected to testify in Myles King's murder case. So why are they now cutting this one off? Welcome to Norfolk County. Maybe Jim did it. They don't want us to hear. I know I can't do commentary because I can't pause it because it's a live Zoom. I mean, I can try and call in, but they just turned it off. Hold on. We'll look behind the curtain. Well, all they're going to do is just get another date because there's nobody there that's going to testify today. So that ain't happening. That ain't happening. Let me try and explain to you at least what we did see happening and what we did hear happening in the other cases. So give me a second because who's in? Stu O'Connell's in the courtroom. They're really just going to get another date on Myles King. Or maybe they didn't want us streaming it. I don't know. Oh, please talk amongst yourselves for a second. No, Brian Walsh is out. Brian Walsh left. They kicked him out. Sheriff was like, yeah, your case is over. You have to leave now. You have to leave now. Well, here's what happened. What you heard was a whole lot of the Commonwealth trying to hide the ball. That's what you heard. A whole lot of that. And there's a bunch of different cases that are all related in which Proctor's text messages are discoverable. So as you may know, during the Karen Read trial, the feds dumped a whole bunch of stuff on Karen Read's attorneys pursuant to the TUI doctrine. Josh Levy, who was the acting U.S. attorney for Massachusetts at the time, had a conference call with both Lally and Karen's defense team and said, in good conscience, I cannot allow this case to go to trial. And therefore, here you go. Here's 3,074 pages, something like that. It contained within those pages were a bunch of text messages from Proctor, and I think maybe an entire phone dump of Proctor. And so they were in the Karen Read case. Now, all of these other cases are pending in which Michael Proctor was the lead investigator, former dishonorably discharged Massachusetts State Proctor, Massachusetts State Police Detective Michael, whatever the hell he is, Trooper Michael Proctor. And so Brian Walsh is one, and there are several others, including Sean Johnson, who is also represented by Rosemary Scapicchio, Giovanni de los Santos, and Bianca Ciancio, who is represented by Joe Cataldo. The three of them, Sean Johnson, Giovanni de los Santos, and Bianca Ciancio, they are all involved in the same case. That's the motion that we heard about the person who helped apprehend Sean Johnson, who wants to remain anonymous. And then there's the Myles King case, and also there is the Brian Walsh case. So the first thing that they talked about, and Lisa Beatty is the ADA for the MassDOT says Joe Cataldo represented Michelle Carter. Lisa Beatty is the ADA for in the Myles King case, and they're talking about this federal order. The federal order said initially, when they turned over this stuff in the Karen Read case, that the materials involving Proctor's text messages, etc., communications, let's just say, comms, must be destroyed 30 days after the resolution of the Karen Read case. That took us, the verdict was, the acquittal was on June 18th, and so that would take us to July 18th, and all of the defense attorneys in the cases that I just mentioned to you were notified the day before, on July 17th. Oh, by the way, the feds say we have to destroy all this stuff tomorrow and we can't therefore give them to you. And so somehow they got an extension of that order for another 30 days, and that is supposed to expire next Monday. Lisa Beatty says we can't turn anything over because that would be in violation of a federal order. And so she said that just today, Judge Casper is the federal judge, that order is to expire on August 18th, which is Sunday, so Monday, because that's the next day. The ADA wants everybody to have to go to federal court and litigate this. They really don't want to do any work. They really don't want to do any work. That's what it sounded like to me. You guys can chime in here because we actually, the whole thing got all screwed up and we tuned in just a tiny bit late. And so the ADA said to the judge, yeah, you can't take any further action. We can't take any further action. Judge Krupp said, I feel like I'm kind of hamstrung here. And the judge says to them, but isn't it true though that you had custody of all this stuff for a year? And she was like, abada. And he's like, well, under Rule 14, aren't you supposed, you have state obligations too. She's like, well, we've been in violation of a federal order. And he said, yeah, but state rules require you to at least look through it. And besides which, I am a state judge and I also have remedies that I can dole out here. So, you know, kind of, it seemed like he was kind of saying, get off the pot. Okay. So Scapicchio says to the judge, or one of the attorneys said to the judge, is there any reason why you can't call the federal judge's session clerk to see if that order was docketed and if we could find out what the federal court is doing with this? And then Krowski says he wants an order for the Commonwealth to turn over all of the materials to his client, Delos Santos. And then the ADA says, then the court says, okay, so ADA, what is it exactly that you're asking the federal judge to do? I think she said she filed a motion like today, right? And she said, well, I asked the court, the federal judge, to give us a court order to permit the Norfolk County District Attorney's Office to review the materials. She's saying she's not even allowed to review the materials because that would be in violation of a court order. And she says, and I also am asking the federal court judge to let us retain the materials for 6 months so that the defense attorneys can pursue other avenues. Like she's going to put it on the defense attorneys now to have to go and do all the work. Because, you know, put the costs onto the defendant and or the state, depending on who's paying the defense attorney. And then she said, and also I'm asking the federal court to toll the destruction date until after these issues are resolved, meaning put everything on hold. We wouldn't have to destroy the materials. Please. And then he says, okay, well, there's an August 5th letter here from the AUSA, which indicates that it would be inappropriate for us to intervene or for them to intervene in the federal matter. And that if they did intervene in the federal matter, meaning any of the defendants, that they would object to that thing. I'm picking up what they're laying down. It's hard when you can't stop and digest, and I can't read my own notes. And then Larry Tipton got up and we saw him defend Penny McGee. We have watched him in front of Judge Frenier. He's defending Brian Walshe. And Larry Tipton was like, Your Honor, it's the Commonwealth's obligation. It's the Commonwealth's obligation to comply with Rule 14. The Commonwealth has failed to even inform the court as to why they can't even review the documents. And in fact, he says, yeah, that's a whole lot of creative thinking and stuff. But last time when we were in front of Judge Frenier, and he said, and Judge Frenier said that she can't hear this particular issue because she has a conflict, because Michael Sullivan, who is the attorney that the Commonwealth has chosen to represent them in the federal proceedings, was her mentor. And she's like, I got to step away from this. I can't hear this specific issue on Proctor's communications. She's got a conflict. He said, during that hearing, Judge Frenier said that Laura McLaughlin has the unique position of being the attorney for the Commonwealth on both the Reed and the Walshe matters. And so therefore we know that she's already reviewed all of the materials. And in fact, at one point, Laura McLaughlin said that there was some information in there that was exculpatory to Brian Walshe. So what do you have to say about that? Laura McLaughlin did not speak at all. There was another ADA speaking for the Brian Walshe matter. And apparently Brian Walshe also filed a motion to dismiss this morning. He's like, listen, they've had this stuff for a year. They haven't turned it over. You should just dismiss all the cases because the Commonwealth can't seem to, turn stuff over. And we've been watching this over and over and over again. And the defense attorney said, can you give us at least a copy of your motion to intervene that you filed with the federal court, Commonwealth? And the Commonwealth's like, yeah, no. Do you think they really filed it? I mean, I don't know. Like, why did they just file it today? This has been going on for how long? Since at least Karen Reed's acquittal, right? So now he says, okay, well, we're all going to have to come back Thursday at 2 p.m. and keep talking about it. We got to see Brian Walshe too. And if you guys don't know, LC was the barber in the Norfolk County Pokey. And when Aidan Carney was in the Pokey at the same time as Brian Walshe, LC was $5 haircuts. He gave $5 haircuts. And I've been saying for a long time when we watched the Harry Turk trial that it looks like he got his hair cut with a hammer. And same thing with Brian Walshe, and perhaps $5 you get what you pay for. But we have also learned through Aidan Carney that LC, the barber, who also was an inmate, by the way, I didn't realize that. I thought it was like an outside barber that they brought in. LC has been transferred, and therefore, as you could see today, Brian Walsh's hair was looking a little choppy. And so there's that. I guess, LC, you're sorely missed. I don't know if you get to watch YouTube and wherever they have transferred you to. And so there's that. And then the Commonwealth has made a motion to protect witness information in that case that I was telling you about that involves 3 defendants, including Sean Johnson. So you got Scapicchio, you got Krowski, and you got Joe Cataldo, who I am told went to Trinity College at the same time that Tom Kokonowski and I were there, but I didn't know him, but Tom does. So the Commonwealth made a motion to protect witness information. There's a witness who apparently helped the MSP when they were looking for Sean Johnson. And they gave him a monetary reward to help them find Sean Johnson. And he got a monetary reward for that. And he's fearful for his safety right now, says the Commonwealth. And so they're moving to not give the identity of that witness who gave up Sean Johnson's location to the MSP. They don't even want to give the information to the defendants or the defense attorneys. And Rosemary Scapicchio is like, what? I'm sorry, what? How can I prepare a case for trial if my client is not allowed to know who this witness is who got money to turn him over? And I love it. I love when there's 3 defendants against 1 Commonwealth attorney because they're all on the same side, or the same snide, I should say. And Rosemary Scapicchio says, or the judge is questioning now the Commonwealth and says, well, when did this witness give you this information? How long have you had this witness? And apparently it was years ago. Years ago. And he's like, well, why didn't you turn over this information years ago? Why are you just making a motion about this today? And if I look at this, Sean Johnson's index number is from 2022. So yeah, they've had it for like 3 years. And, they just gave it to them like now or today, or they don't want to give it to them. That's the problem. And so the judge, like right away, after a lot of back and forth, made a ruling that, okay, you have to give the information to the attorneys. The attorneys can't share like the address or the location of this witness, but they can share the name of the witness with their clients because, defendant has the right to know who his accusers are, right? So there's that. And what about Jim's forehead? I could not see the judge through Jim either, which is why I gave Brian Walshe full screen for a large part of it. And then, so Thursday at 2 p.m. is going to be that continued conference. And some of the attorneys couldn't make it, but they said that Rosemary Scapicchio Rosemary Scapicchio could stand in for them. So they know they're all on the same side, and she will do what's right by them, because we know Rosemary, she's a pit bull, right? And that is not Doolin. That was Judge Krupp today. That was Judge Krupp. They kicked us off the Zoom. They kicked everyone off the Zoom. I don't run the Zoom room, but they kicked us off the Zoom. They stopped it for everyone. So I don't think anybody's got it right now. So there's that. But with regard to the Myles King case, nobody's testifying today. I already knew that going in. Boston 10 apparently did not, because they titled their stream, Michael Proctor expected to testify in the Myles King murder case. And that was not true, because we know it's a non-evidentiary hearing. And so there was not going to be any testimony taken today. They were just going to go over the charts between the Commonwealth and the defense, and who gave over what when. Yes, I know you're disappointed, but listen, there's nothing I can do about it. Laura says, Hightown on Netflix. That is a great show. I love that show. I was so sad when it got canceled. It's a great miniseries about murder, corruption, and drug trafficking in Cape Cod, Massachusetts. It's a great watch with lots of similarities to what happens in Norfolk County. Did anybody else watch Hightown? I loved it. I loved the characters. I was bummed when they canceled it. I really liked it a lot. Thanks, Laura S. for the 10. Elf gifted a membership. Thank you so much. Elf, Dove's House says, what are the odds that AJ and team find new evidence when the Lexus and phones are returned? Thoughts? Well, my thoughts have always been, I'm going to stick to these thoughts, that if any of those devices were tampered with, or the vehicle was tampered with in any way, or the data was tampered with in any way, they may just have witnesses who will be able to prove that, experts. And so I think it's great, because the judge did rule today that she's got to get her property back. No Love, the traveling trooper says, hello, Ms. Melanie and fellow cupcakes. Thank you very much for your super chat. No one, thanks for your 10, says, much love and respect. I paid for a streaming package, my ship to Bermuda this Friday, so I can listen even in the middle of the ocean. That's awesome. Have a wonderful trip to Bermuda. And thank you for thanking me. Jenna says, Mel, you're the best. Come back to Massachusetts. When I drive into Massachusetts, because I do drive through Massachusetts, and there's a big sign that says, welcome to Massachusetts. I look at whoever I'm with, and I'm like, yeah, they don't mean me. So, if you know, thanks, Amy. Tell her for your super sticker. Danny says, I love listening while I work. Each time you're mentioning Reddington, my mind goes to the series Blacklist. Yep. Keep on with your fantastic channel. Thank you. Like IYMI says, I could not do my job if Brian Walsh was on my work Zoom. I wish his name was down the corner. No Love, the traveling trooper says, what are they trying to hide? I don't know. What do you think they're trying to hide? What do you think? Nurse of Interest Jackie says, Rosemary, our spirit animal. Thanks for covering for us, classy. A couple things we can do. We can go over the Michael Proctor Internal Affairs report. I'd like to go over the Karen Reed civil motion to dismiss, but I'd like to make that a separate show because it's a different case, and this is a Myles King stream. So you tell me what you'd like to do. Next witness is Lisa Beatty. Any relation to Tom Beatty? I don't know. I don't know. I would say Beatty is a common name, but you never know. Kelly says, was it not Auntie Bev who helped rewrite or reword Rule 14 before the second Karen Reed case? Yes, she was the head of the committee. She was the head of the committee to redraft Rule 14. You are absolutely correct, Kelly B. Thanks for your 5. Sandra says they'll rue the day they cross Karen Reed. I love this so much. They'll never forget Karen Reed. No, they won't. No, they absolutely won't. Norman, can only imagine how much money this is costing the taxpayers with all this dysfunction. I know. Thank you for your 10. Talk time with Amy. The audacity of these people. Amy in Boston. Love. Thank you, Kat Randall, for gifting a membership. And also, Tony gifted 5 memberships. And Skybell gifted a membership. And you're awesome. And Jadzia says, won't Karen's team need that material for 1983? Karen's team already has the material. That's the thing. Karen's team already has it. And because that trial's over, that's why it's supposed to be destroyed. So, thank you, Jadzia. Great question, but they already have it. Bridget says, enjoying a peach margarita on this 90-degree day in Rhode Island, thanking me for all that I do. Thank you guys for watching. Jim's Forehead is here for 5 months. Thanks for the idea. I needed a name change. Oh my God, that forehead was too much, wasn't it? Wasn't it too much? All right. Hang on for 1 second. All right, let's do this. I don't know what is happening with, as such, whatever's going on in the Myles King case, but we can always catch up on that later. So what I'm going to do is we're going to start a new stream. We're going to go on over. I'm going to teleport you there. Give me 5 seconds to fill up my drink, and you can all do that too. And we will teleport on over and we will read through Karen Reed's motion to dismiss on the civil case, because that is my wheelhouse. And I'm very excited to talk about that. It'll be a cold read for me, but you know, that's how we roll. That's how we roll. Okay. Everyone smash the like button on your way out, and then smash the like button on your way in, because that's what we do. And see you over there in a few seconds. Hopefully it works for you. If not, just go on my channel. All right. Thanks to the moderators. This was kind of a short one today, less than 2 hours, but we will figure out what happened on the Myles King case later because they kicked us out of the Zoom. Do all the things YouTube likes, and I will meet you over there. So buckle your seatbelts, my friends. I will see you in 3, 2, 1. Safe travels.